Okay, we leave the world of sprinkler heads, and our second and final case this morning is case 24-1550. Joel, is it Gingery? Gingery? Yes. Okay, Joel Gingery, thank you, versus the state of Florida. All right, Mr. Offerman, whenever you're ready, sir, you may proceed. Just tell the marshal how much time you'd like on your rebuttal.
Good morning. May it please the court. Michael Offerman on behalf of the appellant Joel Gingery. I'd like to reserve 5 minutes of my time for rebuttal.
Thank you.
I intend to begin my argument this morning with the first claim raised in the briefs. I'm also hoping to address the third claim, and then I'll answer any questions that the court has regarding the remaining claims. The first claim in this case concerns the trial court's error in overruling defense counsel's objection to the state admitting not only the audio of the controlled call, but also the video. Defense counsel below argued that, look, Judge, the only reason they want to get the video in is so that the jury can see the alleged victim crying during that controlled call. Now,
What's the difference between seeing her crying and hearing her cry?
Extremely different in this case.
How?
Because on the audio, you can hear her cry a little bit. And that's normal for the controlled calls that I've heard that have, as I said in my briefs, have only involved audios for the dozens of cases that I've reviewed, sexual assault cases that have controlled calls. But in this video, we have the alleged victim crying throughout the entire controlled call. And at times, she's crying uncontrollably. She has her head in her hands down while sitting on the couch for substantial periods of time. She is sitting next to a victim advocate who is consoling her the entire time with an arm around her, rubbing her shoulders. That image, and as I said, I've quoted from the Texas
Is the jury entitled to view that in order to weigh the credibility of the accusations made and the basis of the call?
Absolutely not. Jury entitled to review a video of a controlled call?
Is it relevant to the credibility of the accusations?
No. So the detective in this case specifically said what the purpose of a controlled call is, and it's the purpose that I know the three of you as trial judges are aware, and you've heard hundreds of cases that I'm sure you presided over. The detective specifically said, we engage in controlled calls as a tool to try to get the accused to make a confession.
Sure.
Has nothing to do with the alleged victim being emotional and bolstering the credibility of the alleged victim. Now, that may come out. You might have controlled calls where the alleged victim is in fact emotional. In this case, if the audio had been played, the jury would have heard a little bit of crying. But to see her crying the entire time, and then more importantly, we don't have to speculate as to why the prosecutor wanted this in. Now, the judge, of course, said, and it wasn't really argued by the state, but the judge says the probative value of the video, because the objection specifically was, defense counsel says audio is okay, we're objecting to the video, and the judge overrules that and says the probative value of the video is it's probative of the fact that this was a controlled call. That's clear error. That's just clear error. It's not a material issue in this case as to whether or not this was a controlled call. Defense counsel was crystal clear that we concede that this is a controlled call. As I said, I've had dozens of controlled calls, and it's never been an issue where someone had to actually show the video to establish that it was a controlled setting where the call was taking place. Many controlled calls occurred in a park, in other places. They don't always occur in a law enforcement station. But going beyond that, the reason that we know why this prosecutor wanted the video to come in is in the closing argument, page 446. One of the factors you can look at is that the alleged victim, yes, she got very upset. You saw how upset she was here on the stand. You saw her demeanor. You saw that she was shaking. You saw her on the video when she was crying during the controlled call and how upset she was. I'd submit to you that someone who was lying couldn't think that for that long. The prosecutor is telling the jury, find him guilty, believe her, because you saw her crying on a controlled call video. Why did that come in?
Do you interpret that as an invitation to the jury to be swept away by the emotion of the call?
Yes, without question. This is a 403 case. And this is a poster case for what would be the prejudicial impact far outweighs any probative value when we're talking about just the video.
In the portion of the closing argument of the prosecutor you just read, did he reference she was emotional at the time of giving testimony in trial?
Sure, that's irrelevant. That's not the issue. That's not the point that was being made. Of course, alleged victims and other witnesses throughout trial proceedings may become emotional. Sometimes judges take breaks. The point that was being made here was she was crying at the time, the next day when the controlled call took place. That's why you should believe her, because she couldn't be lying for that long. You couldn't just make this up. But there's even another factor here in this case. Another
They made
factor.
that same argument based just on the audio of the controlled
But
call.
that's not what defense counsel argued. And I submit to you that the audio is nowhere near. So I quoted from the Texas Supreme Court that a picture is worth 1,000 words and a video is worth exponentially more. That's clearly the case here. It's one thing to hear her sniffling on the audio. It's far different to see her crying uncontrollably on the State's Exhibit 9, I know you've seen it, on the couch, victim advocate wrapped around her, hands on her head, while her head is buried in her hands, crying. There's no probative value of that, or to the extent that there is, it is far outweighed by the prejudicial impact. That is screaming for the jury to make
The unfairly prejudicial impact.
unfairly prejudicial impact. It's a
I know
403,
403 doesn't address prejudicial impact. It addresses unfairly prejudicial.
and this would be as unfair as it gets.
Okay.
The video was used to elicit sympathy, and we know it from the prosecutor's own words. And then there's another factor here. And this is why this becomes so dangerous. Maybe you've seen it in your other records. I have never seen the video of a controlled call played, and I've certainly never can imagine that a prosecutor would then get up in closing. And again, in this case, it's not only what I read to you, it's the very last thing in the rebuttal closing that the prosecutor played for the jury, and again said, the controlled call is what it is. That video is what it is. This prosecutor was really relying upon this video to make the point that believe her now because she was crying back then and she couldn't have been lying and still been crying a day later if this wasn't true. But there's more to the story, isn't there? We know that the victim coordinator told her prior to the controlled call, quote, all I need you to do is cry during the controlled call. Page 236. Defense counsel said it 3 separate times. Now, the judge made sure that portion was not shown to the jury. But wow, shouldn't we all step back and be concerned here that the state is manufacturing a situation for an alleged victim to cry so they can take a video of it, then show it to the jury, and then argue to the jury, believe her because she was still crying a day later after this incident. And she couldn't be lying and making that up and still be crying a day later. I'm offended when I saw this. This is one of the worst things I've ever seen in any of the cases I've worked on. The state of, again, there's evidence that comes out during these cases that other people come into contact with alleged victims after these sexual assault allegations. You might have someone, the sexual assault nurse, say at the hospital that, what was she like when you came into contact with her? She was distraught. Okay, the state can rely upon that. That's the fact. That's the truth. It's not manufacturing evidence. It's the way that it was. In this case, we actually have that. We have Brittany Bell, the mom of the alleged victim's best friend, who said that right after the incident, she called me and she was screaming. The jury got to hear that. The state can rely upon that and say, look, ladies and gentlemen of the jury, you heard from the best friend's mother who said that shortly after the incident, she reported it. Now, of course, the defense would come back and say, look, we got to see the surveillance videos from the hospital. We got to see her walking in at 10 o'clock. She looked excited to be walking in with him. We got to see her walk out at 10:45. He walked out with her. She wasn't distraught then. She wasn't crying. So it goes both ways. The defense certainly had an argument that, no, this was consensual sex, and after the fact, she's making this up. But wow, to create this video where the victim coordinator tells her you need to be crying, consoles her the entire time, and then that's played for the jury, and then highlighted not once but twice in closing argument with the specific argument, I'd submit to you that someone who was lying couldn't be crying like that on that video. That's unfair prejudice under 403. That's specifically eliciting to the sympathy of the jury. It's asking the jury to make a decision based on sympathy, based on an emotional response, rather than the facts of the case.
Let's talk about your third issue.
You know, Florida law it is what it is. And the state makes an argument that Justice Grimes in the Amos case, correctly, the state argues, points out that by the time Bova had been decided, or after Bova had been decided, the United States Supreme Court switched gears a little bit and said there's a difference between an overnight recess and a shorter recess in the middle of a trial. But the state's answer brief would have this court believe that somehow Justice Grimes was saying that Florida law, therefore, should be in line with federal law, but that's not what Justice Grimes is saying. And I'll quote from this is page 164 of the Amos opinion. He says, even acknowledging what happened in Perry following the Geters case, of course, under Bova, it is also impermissible to keep a testifying defendant away from counsel during a short recess. So Justice Grimes himself acknowledges that.
Well, he acknowledges what Bova holds. He doesn't necessarily express agreement with it, does he?
Yeah, I'm sorry. So let me, that's the point I was trying to make.
Okay.
He acknowledges in a dissent that Bova holds, and then Amos continues to hold, because he's in the dissent, that Florida law says that you cannot restrict a defendant from having access to counsel for any period of time.
And so I don't know that let me speak for myself. I don't know that I would disagree as to what Bova holds. I'm curious, Bova predates Perry from the United States Supreme Court. Perry seems to endeavor to address what is termed a shorter recess, whether that's 15 minutes, whether that's an hour, which Justice Grimes seemed to say that's more toward the Perry recess, perhaps.
Correct.
I'm curious, does Bova then conflict with Perry? In other words, they seem to be two different outcomes on sufficiently similar circumstances.
Conflict if Bova is based only on U.S. constitutional law.
You're walking me right there. We sleep on the Florida Constitution entirely too often. I'm going to get there with you. But ultimately, would you agree that as it pertains to what the federal Constitution requires, Bova is different than Perry as announced by the U.S. Supreme Court?
Yes.
So my question is this. What is the origin? Judge Forrest in the Fourth, for whom I have considerable respect, makes a statement that his court, I believe, may have made previously in the Cadavid, I hope I'm pronouncing that correctly, the Cadavid case. He quotes Mears. Mears seems to rely on, if I recall correctly, a second DCA case. But
Weirdman.
Yep. So it seems to suggest that the Florida Constitution provides greater protections than the federal Constitution. I'm curious the origin of that statement. I'm curious as to the basis, legal basis, for the statement of a district court of appeal in the state of Florida that the Florida Constitution provides greater protections than the federal.
Because Leardman says that in Bova, when the Florida Supreme Court made its ruling, it immediately it cited to both the Sixth Amendment and to the counterpart in our state constitution.
Would you concede there's nothing in the text, history, or structure of the Florida Constitution that compels that conclusion?
Yes.
Is there any binding precedent upon this court that mandates that conclusion? I understand.
Yes.
I understand. What is that?
That would be Amos. Because Amos continues following Perry to say, and Justice Grimes recognizes it, that under Florida law, as interpreted by the Florida Supreme Court, the defendant is entitled to consult with counsel regardless of how brief the recess is.
And let me articulate my question more precisely, and I don't want to get you into your rebuttal time. Amos does not declare expressly that the Florida Constitution grants greater protections. You agree with that? You
do agree
concede
with
that.
I concede that.
But by its holding, it provides that, is your point.
Yes. And I think every DCA that's ruled on it,
They're following BOVA. I totally, listen, Perry changes BOVA.
it does.
And let me be very clear with you. I'm not suggesting for even a moment that we are at liberty to disregard Florida Supreme Court precedent. We happily
I know you
yield.
wouldn't do that.
We happily, joyfully, willingly yield.
Of course.
That said, Perry and BOVA are different. And now it becomes, what do we make of Amos, the Amos case, which is post-Perry, in the responsibilities we have in considering whether we are continue to be bound by BOVA?
I agree completely, other than, again, despite all that, Justice Grimes still says, as I just quoted, under Florida law, that's his dissent in Amos, this is where we are, and this is what, in essence, you can read into that, this is what the majority is continuing to hold post-Perry.
And the trial in Amos that was, actually came up to this, that actually occurred after Perry.
Correct.
So, short period of time after Perry, and, not all, we're all trial judges before, so the fact that we didn't know something that was decided the week earlier by the Supreme Court, that's tough to pin on the trial judge, but chronologically, that's what has to be done.
When I clerked at the Florida Supreme Court, every time that occurred, I always dropped the footnote that said, at the time that this occurred, this was in the pipeline, and the trial judge would have had no idea that the change was occurring. That's true.
Your conclusion is BOVA is determinative. BOVA and Amos are determinative
Amos.
under both federal and Florida Constitution.
Amos, well, no, the only way my client wins on this claim is under the Florida Constitution. I acknowledge under the federal Constitution, the law has changed.
Okay.
Justice Grimes explains that. I think the state explains that in their answer brief, and that's true. We are waiting on what the U.S. Supreme Court's going to do in the Villarreal case.
They haven't issued they had oral argument, they haven't ruled yet.
That's it. I checked again this morning. They had oral argument, I believe, in October, and we are waiting on that ruling.
But that's an overnight recess.
I'm sorry, what's that?
That's an overnight
That
recess,
is an overnight.
is it not?
Correct.
That's very different than a 15-minute recess.
They may not provide more guidance to this
Okay.
particular issue, but they're at least considering the issue, and we'll see what they say.
Okay.
I see that I'm in my rebuttal time. I'll reserve the rest of my time. I, of course, hope that you don't reach that issue at all, because I think the first issue is so clear-cut, so prejudicial, and clearly not harmless for the jury to have seen that video, and then for the prosecutor to have it be the very last thing that's said to the jury.
But if we go on issue 3, and how you're arguing Amos is what Amos is, that would theoretically give the Supreme Court the chance to view that again in the context of.
It would be interesting, other than issue 1 clearly requires reversal.
Okay. All right, thank you, counsel. All right, Mr. Bradford, whenever you're ready, sir.
Good morning. My name is Robert Bradford. I represent the state of Florida in this matter. With respect to issue number 1, Judge Dowd, I think you kind of hit the nail on the head. Not only was the video of the controlled call probative, it was necessary to the state's case in that the defense offered evidence that this was consensual sex and that the victim simply changed her mind, regretted it because she had slept with her best friend's boyfriend, and then apparently she started lying and saying that she was raped.
What's the time frame between the crime that the defendant was convicted of and when the controlled call was made?
I think it was the next day.
Okay.
When she presented at the hospital as suggested by her best friend, and I think her best friend and maybe the best friend's mother, she was emotional there too, right?
Yes.
To the extent, couldn't really talk to the triage nurse, had to hand the phone to
As
the
I
triage
recall,
nurse.
that's
Okay.
correct.
Is that
Same
right?
way
Is that
she
a-
was-
Go ahead, I'm sorry.
I was the same way she was upset on the phone when she first called.
Is that relevant to our evaluation of the prejudicial impact of the video of the control call?
I think it's all relevant. It's relevant because of the defense. Because if this 18-year-old girl had simply regretted sleeping with her best friend's boyfriend, would her crying be that extensive? That's the question. Can the jury reasonably infer that she was upset because she regretted her actions and it may cost her a friend, or would she regret it because she was forcibly raped? That's a completely different issue, and that, I think, makes it necessary, and why, even though it is prejudicial, it's not unfairly prejudicial.
What weight do we give to the state's instruction to cry on the video?
I think that is the jury's job to give weight to that evidence, and this court should not reweigh any
The
of
state
it.
instructed her to cry on the video? Or was that part left out?
I don't believe that was put before the jury. If it was, it doesn't matter. I mean, she's consoling. My argument on issue number one is two-part. One is, I don't think they meet the abuse of discretion standard in that no reasonable person would hold in a manner that the trial court did. I think it's certainly subject to a difference of opinion.
Hold differently than what the trial judge did.
Yes, I'm sorry, my apologies, yes.
There you go.
So,
Kind of what Mr. Offerman's argument was. No reasonable judge.
I'm sorry, I'm just been dealing with a handwritten pro se petition that speaks in double negatives for 60 pages. So, anyway, so the probative value, I think, is clear, and because of the defense presented, it was not unfairly prejudicial. That is the significance of that point.
But his argument is the victim advocate, who I guess is an agent of the state, so to speak, is telling the alleged victim at the time, I know she became the victim after the conviction, but that make sure you cry. I mean, isn't that kind of disconcerting, for lack of a better?
If she had only cried during the control call, I think that might be.
No, to make sure you cry. If I don't want to misquote what Mr.Ufferman was saying in oral argument, but that basically it was like, okay, you're on the control call, make sure you cry real hard here, or make sure you cry a lot so that it shows what it shows, I guess.
And I mean, that I would imagine would inure to the benefit of the defense, saying that it's all structured, that it's not real, that her tears are crocodile tears.
Did the jury hear that instruction?
I don't think they did. They may have, but I
Wouldn't it
I could
inure
be
to
wrong.
the, I'm sorry, I didn't mean to cut you, go ahead.
Just that if the state actors are telling the victim how to act, that I think could be argued to be that they're fabricating evidence.
Well, it would inure to Mr. Offerman's client's benefit if the victim was matter of fact, talk flat out, had no emotion. I mean, that would be more suggestive of his defense that this was a consensual act between adults. If, I'm crying, sobbing hysterically, or whatever term was being used, I'm not trying to put words in anybody's mouth, that suggests that this was something that I didn't want to have happen. I was the victim of a sexual battery, and that would be, I assume that's why the state wanted to present that evidence, because it supported their case, right?
And it opposed the defense. It neutralized the defense, which was she regretted it, and there's a difference. I think the state was trying to make a point that there's a difference between an 18-year-old who regrets having sex with her best friend's boyfriend and an 18-year-old who was forcibly raped.
Mr. Hoffman's argument is basically the victim advocate saying, make sure you cry real loud when you're on this controlled call.
The issue is whether the video was admitted into evidence, not specifically whether the jury saw the state actors say, I need you to cry. That's not the issue here.
It's the video as a whole.
It's the video as a whole.
In other words, the point on appeal is not that the court erred in redacting that portion of the video. Make sure you cry.
No, that's not the issue as I recall it from the initial brief.
If I heard Mr. Ufferman correctly, that portion was redacted.
That's my understanding as
And
well. The jury didn't hear that.
And I'm trying to recall the transcript. I'm trying to recall the record precisely. That's what I heard him say in argument. At some point, I'm curious to get to the third point on appeal. I'm curious as to whether or not we are bound by Bova and Amos.
Sure. The only other thing I wanted to say with respect to issue one was the harmless error argument. The fact, and I just don't see any difference if it's the crying that's a problem. I don't see how her crying. The jury heard that she cried when she called her friend's mother in Washington or wherever she was out on the West Coast. She cried during the control call. She cried during her testimony at trial. And again, this goes to the regret versus her lying.
What about the argument that she's credible because she cried during the controlled call, even though we told her to cry during the controlled call?
Again, the jury didn't hear, to my knowledge,
That's
that
the
we told
problem,
her
isn't it?
control. They didn't ask to put that in. They could have asked to put that in. They didn't. So I think we're stuck with those parameters, that it's just the video of what was shown to the jury that's being discussed here and what was objected to. But again, if she's consoled several times, do you need water? Do you need to take a break? There's no rubbing of her back or anything, but she's crying. And I would disagree with my new friend's suggestion that you can barely hear her cry on the audio. I think it's clear. I think it was described in my answer brief exactly the extent, and I think he even copied that description in his reply brief. You could hear it. It was clear. It was clear how upset she was. Now, with respect to issue number 3.
Well, let's tee this up to some extent.
Yes, sir.
In Bova, as Judge Sow was referring to, we have Bova. Later on, then the U.S. Supreme Court in Perry rules what it rules on the Sixth Amendment, and then we have Amos. Now, the question then in Bova, and I'll just read it because it's what they wrote. The question presented for review is whether the constitutional right to counsel prohibits any restrictions on attorney-client consultation during a trial recess. I think that was a 15 or 10-minute break, I believe, in that case, and they eventually. But when they frame that question for their consideration, when they talk about the constitutional right to counsel, they cite both to the federal Constitution and to the state Constitution.
That is correct.
In footnote 2, you agree with that? All right, so at some point, the U.S. Supreme Court basically, it says in Perry, it's not a Sixth Amendment violation to prohibit, which that part you like, right? All right. So we still have the the Florida Constitution hanging out, and the concern, and I think Judge Soud expressed it eloquently, is whether we like it or not, we have Amos. Certainly the Florida Supreme Court was aware in Amos of the decision in Perry. It was only a few years ago, and more to the point, their colleague talked about it in his partial dissent. That didn't seem to move the Amos court to step away from Bova and say, well, 15 minutes, you can't have a consultation during 15 minutes on either the federal or the Florida Constitution. Do you agree that's the lay of the land? I know you argue what you argue, and you certainly have 10 minutes to talk about it, but
I think
that's the lay of the land that we're looking at.
Under Florida law, there's no risk. You can't have no restrictions, and
Under the Florida Constitution, apparently.
Yes, apparently.
The federal Constitution, and in fact, I think Justice Grimes even mentioned in his partial dissent, he said, well, under federal law, that's,
he cited
that's by the
Perry
wayside,
and
yeah.
distinction.
There was no error under federal law, specifically what Justice Grimes wrote in his partial dissent. He thought it was harmless error because Mr. Amos, on his, I guess it was his 5th trial, he's clearly guilty, and I guess that was his extrapolation of the harmless error test. But he said it was harmless error there, and so under that aspect of the case, he said, well,
Yeah, Your Honor, I went back. The Bova court cited to, of course, Getters, and it also cited to a state case named Style Stripling, which actually was a 2-hour lunch recess that was taken between direct and cross. All of these seem to during direct and cross. Almost.
we're having a unique scenario in the courts about 10 minutes, 15 minutes, hour, 17 hours overnight. Apparently, there's the constitutional right varies depending upon the clock.
And I think that brings up a good point in this case, because I think the original recess was for 15 minutes, but then they addressed a couple of matters after the jury left, and so then they were going to take, so that was maybe 10 minutes or so, and so they only had about 5 minutes left, and then they took a comfort break, and that's when he announced don't talk to your attorney. So this is even a smaller recess than in any case I've ever seen, which is 5. And I think it's important to remember that when you're talking about, to recognize the distinction between getters at the overnight or a big 2-hour lunch break or whatever, when you can sit down and strategize and talk way more about things than just the defendant's testimony. Whereas if you've got 10 minutes, 5 minutes, 15 minutes, there's almost a presumption that's what you're going to testify to. And in this brief, that's exactly what he says. He wanted to coach him on how to say these things without getting a hearsay.
And that calls into question the integrity of the evidence presented.
Exactly.
I understand that.
It's a truth-finding process. I understand the defendant's rights, but the whole thing is designed to find the truth. And if you start overcoming cross-examination, which is a component of the truth-finding process, if you start chilling the effect of cross-examination by letting him speak to his attorney about his testimony and how I can better say it and get my point across, that's I think too much of a compliment.
Listen, the ink flows from the pen pretty fluidly on that issue, in my view. And yet, Amos. And yet, Bova. In other words, Amos, I think, was an hour-long recess. And let me say this. I understand the notion of the peculiarity of now we're talking about the right to counsel with a 10-minute recess, 15-minute recess, hour-long recess, 2-hour recess, overnight recess. I understand that. But directly to your point, it is entirely about what it is counsel's going to be able to discuss during the duration of the recess.
Exactly.
You can talk about trial strategies and other matters beyond cross-examination with a longer recess. Every trial judge knows if you have a 5-10-minute recess, there's barely time to talk about much in the courtroom. And for defense counsel to go to a holding cell area if the defendant's in custody, you really have no opportunity to talk about anything else.
Exactly.
And how often then are we going to invite defendants to claim a need for a recess in the midst of after a direct, before a cross, for final instructions and guidance on cross? I hear all of that. What do we do with Amos? Amos is an hour. Maybe it's factually distinguishable. Maybe Perry speaks, but we still have Bova referencing the Florida Constitution, and Bova and Amos, does that bind this court from the Attorney General's perspective? We're not at liberty to disregard it. We do not want to disregard it if it binds us.
I can't argue that this court is not bound. It is. I think it is. I think it has options on what to do to, maybe represent this to the Supreme Court and have them take a second look at it in light of Perry. What's important is in the case of Traylor versus State, the Supreme Court talked about construing the Florida State Constitution Bill of Rights, for lack of a better word, Article 1, Section 16. And it says that they should focus primarily on factors that inhere to the own unique state experience. This is the express language of the constitutional provision, its formative history, developing state law, evolving customs, traditions, and attitudes, et cetera, and then finally, any external influences that may have impacted state law. That would be getters.
Well, let me ask,
And one more thing, if I may, Your Honor.
Yes, sir, go ahead.
With respect to this particular court, in Peoples versus State, this court in 1991 found that the language used in the Florida Constitution to be heard in person by counsel or by self or both provides no stronger rights than the Sixth Amendment to the U.S. Constitution. Now, that was not an access to counsel case, that was a right to counsel case. But still, this court interpreted that language.
In Bova and in Amos, with Bova creating this concept that we're dealing with today, they both ended up finding it was harmless error.
Yes.
Is that in your view, a viable scenario here?
Absolutely.
Did you raise that in your brief?
No, I did not.
Well, let me ask, we're not precluded from independently doing a harmless error analysis, are we?
I would suggest that you're bound to under state law.
Well, I was just throwing the chum out here because there actually is there's a Florida Supreme Court case, Heuss, H-E-U-S-S, that says the question of the case is whether or not an appellate court may engage sua sponte in a harmless error analysis, and the court said yes, and I think there's subsequent cases that suggest that we're obligated to. But at the
think-
very least, we can sua sponte do it,
I
because that
think
was
you
the clear,
can.
that was the clear question that was asked in Hoyce 30 years ago.
I think you can do it sua sponte, but
Let's say we do that in part of our overall analysis in this interesting case. So why would this be harmless error in the sense that this is kind of there's not a lot of dispute about the physical evidence. This is a
Exactly.
he said, she said. So doesn't that make it more likely not to be harmless error?
Well, I think if you consider the objections during his direct testimony and his redirect testimony, there were, as I counted, about 24 different hearsay objections. Several of them were based on the questions themselves. What was the agreement? What did she say next? I mean, they expressly called for a hearsay answer. Sometimes they were talking about the specific acts. I asked her to whatever, she said, wait, do this, whatever. I mean, it was not, it was about
He had
topics.
a different view of what happened.
Well, of course,
Yeah.
but my point being is that the materiality of all of these topics is not important. He was either able to rephrase the questions or the answers, or there were no, I think, maybe one motion to strike. I mean, the jury certainly heard these answers, but
So
the
you think
importance
it's harmless because whatever the consultation that was precluded, Mr. Defendant ended up getting his testimony the way his consultation would have directed him, or helped, not directed, no coaching, no direct, would have, under advice, would have formulated in that direction?
I have two responses to that, Your Honor. One is that he was able to put before the jury his entire defense, that he was cheating on his girlfriend with the victim, he lost his jiu-jitsu school because of it, that they had a signal worked out where they would how to meet and how not to get caught, considering his schedule and his girlfriend's searching his phone, and the fact he was able to get the fact that she actually initiated physical contact that night in the call room by hugging him and kissing him. He was able to testify that she did not fight him off in any way as they were having sex, and that she was flirting and smiling and waving at him as he sneaked her out of the hospital, or snuck her out of the hospital.
Well,
So there's no reasonable possibility. He got his complete defense. And so therefore, I do believe it was harmless error. And if Your Honor, this is the most important thing. Not once, but twice during his testimony, he was instructed by the court to stop saying what people told him and to say only what they did.
Well,
His counsel also told him twice in the courtroom on the record. What possibly could counsel have said to him in private that would have made any difference? The judge, the second time, I mean, the first time he was just very plainly, you can't, after you did it 2 or 3 times, you can't say what people said to you. And then later on, you could see the judge was getting a little frustrated. And he said, do you have a question about the fact that you're not supposed to say what people said to you? Obviously getting a little snarky because he kept doing it so much. But the bottom line is, if that didn't convince him, he couldn't say things that people told him. What possibly could defense counsel have told him in those 5 minutes?
Well, since we're speculating, since we're kind of chewing the fat over the Amos, the harmless error test, explain that to me under DiGiulio. I mean, you can't
no
look at you
reasonable-
can't look at the weight of the evidence, overwhelmingness, et cetera. It's whether it would have whether it would
There's
affect.
no reasonable possibility that it affected the verdict.
Well, isn't that based upon the evidence?
Well, it is based upon.
I mean, I know
that.
somebody's got to write something to explain how it's harmless error. I've always been interested in saying, okay, it's not the sufficiency of the evidence, the weight of the evidence, the overwhelming evidence, it's that long.
It wasn't
Descriptive paragraph.
unfairly prejudicial. I mean, I'm sorry. It just,
Maybe when Judge Saud's writing about this, he'll say, not only don't I like Amos, I'm not too big of a fan of DiGiulio either. But I'm just pulling your leg.
the bottom line is he got his complete defense out in front of the jury. They heard it. So it didn't.
Okay. Thank you, counsel.
Thank you, Your Honor. The state would ask for the judgment and sentence to be affirmed in all respects. Thank you.
I figured.
May it please the court. I'm going to
You helped
quickly.
write that back in 1986, the harmless error test, or was that before your time?
That was before my time. I was 97 to 02.
All right, go ahead.
Quickly on harmless error, and then I do want to jump back into claim one. It's not harmless because potentially the most damaging thing that came out during cross-examination was this, oh, you've had 19 months to come up with your answer. And clearly had one of the things you could imagine that defense counsel would have said, okay, we're getting ready to go on the cross. They go at you for, what you're getting ready to say. You come back and say, I may have had 19 months, but what I'm saying today is the truth. But no, he did not have a chance to say any of that. He was kind of caught flat-footed with that question, and the state can't prove beyond a reasonable doubt that had there been consultation, that my client may have done a better job with that answer.
But play that out just a minute. I would imagine, would there be an opportunity, of course, I never allowed to recross, but, you had a chance to talk to your lawyer during the course of this 5-minute recess, didn't you, if recross would be allowed? I mean, there's a lot of ways that this can play out. I'm curious as to your best argument as to how your client was harmed by being precluded from talking to his counsel during the 5-minute recess.
I just gave it to you.
Yeah, and I think you did. But if I understood the briefs correctly, part of the argument is he could have helped him avoid this repetitive hearsay issue.
I don't want to focus on that as much because I think some of that did occur before the request to consult with counsel even happened. So that's why I'm sticking
Okay.
with the point I just made.
Okay.
I have a minute left. Don't fall down this slippery slope of allowing videos to come in these cases. This is an adult. It's not a child hearsay case. In child hearsay cases, there's an exception the legislature has made. The jury gets to see the video of the child. That's not a dispute here today. I'm not going to argue that. But for adult cases, we generally allow the adult's accusation to be what's said on the stand, and that's what the jury relies upon. We could imagine situations that this is now going to set the slippery slope where, okay, when you come in to meet with the detective, let's record you as you're coming in. You're crying. When you go in to meet with the sexual assault nurse, let's record you. It's one thing for the nurse to say, oh, she was distraught. But now we're going to, in every case, get a recording of you crying. Because everyone knows it's logical, it's far more powerful to see the person crying. And that's why the prosecutor said in closing argument, you saw her on the video when she was crying. Not you heard her, you saw her. This video should not have come in. The judge said it came in because it showed it was a controlled environment. No one's defended that. That's a ludicrous ruling. That's error. The video should not have come in, and my client didn't get a fair trial because of it. Thank you.
All right, thank you, counsel. Interesting argument. All right, gentlemen, we will take it under advisement. We stand adjourned. Have safe trips back to